Anyway, I want to introduce myself and kind of give a couple of real quick housekeeping stuff before we get started in the program itself. My name is James Branum. I'm a civilian attorney. I've been practicing for about 11 years now, mostly in the area of military law. I've represented a good number of military members of active duty and reserve members of the U.S. military, particularly from the U.S. Army, who are dealing with issues of conscience, but who are also wanting to be discharged for a variety of reasons. And I help them to navigate the system to find the best way out. I also defend some who are entangled in the criminal justice systems, which is the topic for today's presentation. So, also to mention real quick about our sponsors, this program today is being brought to you by two groups, the Center for Conscience in Action, which is the group I work with here in Oklahoma. We're an organization that works in a variety of human rights issues, including military law issues. We're also co-sponsored today by the Military Law Task Force of the National Lawyers Guild. This is an organization of military law practitioners, including attorneys, legal workers, and others who are engaged on military law issues. Find out more about them at their website, nlgmltf.org. Anyway, though, let me just go real quick. Housekeeping issues. If you have not already done so, you should download a copy of the manual for courts martial. We'll be using that today. So 2016 edition is the newest version that's compiled all together. You can find that if you go to the website for the CLE, centerforconscience.org/CLE. There will be a download link there where you can download the whole thing as a PDF. So we're going to be referring to that often in the program during both hours. So you want to have that ready. Also, if you're wanting to have a chance to get CLE credit for this presentation, I need you to, at the end of the program, you'll need to email me. My email address is girightslawyer@gmail.com, and that is again, girightslawyer@gmail.com. And email me with your name, your state, your bar number, and then there will be total four codes given during this program. 2 for the first hour, 2 for the second hour. So when you hear those codes, please write them down. The bar requires this as proof that you attended the presentation. If you send those to me, I'll have proof that you did attend, particularly for the live webcast. It's especially important we show that you're watching it live. We'll have different codes for the on-demand broadcast. But if you watch it live, you get credit for that, depending on your state's rules. So send those to me. If you're in Oklahoma, we have a pending application for CLE credits. You hopefully, no hiccups involved. You'll be getting credit for that and before the end of the year. So you'll be good there. If you're from another state, what we will do is send you a certificate along with a uniform application for accreditation of CLE activity, which most states will honor. You may have to pay a nominal fee for that, but other than that, it's usually a pretty easy process. And so anyway, it's up to you, though, if you want to do that or not. So anyway, housekeeping out of the way, let's go ahead and get started in the presentation. I'm going to take off the jacket. A little bit hot today. So for this first hour, we're going to be discussing, comparing and contrasting the military and civilian systems of military justice. And part of the rationale for why I'm wanting to do this is that I believe that a lot of civilian attorneys out there, one, would like to know more about this system, but also are quite intimidated by it. What little many of us know is from TV, from old reruns of JAG or something, but very little practical experience. And so this leads to some negative outcomes. One is that a lot of really good practitioners who would be great attorneys defending military service members who are needing outside assistance sometimes don't get that help because they are intimidated, they're nervous, and they think it's much more complicated than it actually is. On the other hand, there's also attorneys who go into this too blithely, too flippantly, not understanding some of the key differences in the system. And not just the differences procedurally, but more importantly, equally important, the cultural differences. And so today I want to give a little bit of an introduction to some of those differences because I believe that having this knowledge is power. I also, though, my hope with this program is also to hopefully persuade some people to step into this area of law. I think it's an important one. It's one that we need more people doing. So, and finally, one last thing I'll mention is that there are lessons to be learned. Many attorneys, we care about the system. And so many of us are involved in various forms of advocacy to make the system better. And there are things that we can learn from the military system of justice that will be very helpful the things we learn in the military system that will be helpful in the civilian system and vice versa. There are things the military does better than the civilian world, and there are things the civilian world does better. So I'll talk about them, particularly some very specific procedural things that could be a great improvement. And so whether you ever intend on doing military law yourself, knowing about some of these differences and how they work can be useful in other arenas. So, okay, so if we now delving into the nuts and bolts of what's different and what's the same about the military system of justice versus the civilian system of justice. Well, you have to begin with the philosophical side of things. At the very base, at the most important level, what is the goals of these two systems? How do these systems, what are they trying to achieve? Well, in the civilian system, and again, this isn't always stated in statute, but in theory and discussions, you often hear the ideas of retribution, of deterrence, of rehabilitation, and of course of justice and fairness. But these are things that the system wants to be not convict the wrong people. It wants to convict the right people who have committed acts, and then by having that conviction, then those goals and punishment of retribution, deterrence, rehabilitation can be brought about. The military system of justice is similar in that it has many of those same goals, but with one little, and well, I should say huge wrinkle, and that is the idea of military discipline. The idea is that for a military to effectively function, to do its work, and whether you agree with the work or not, the system is built upon the idea that the work must be done. Then it requires discipline. And so that affects the issues of deterrence. In other words, often soldiers, service members of various kinds are punished not for so much of the effect upon them, but as a deterrence to other service members who might be contemplating the same action. So that's a very different wrinkle. And because of that wrinkle, the courts have granted the military authorities some extra latitude in some ways in bending the rules when it comes to the Constitution and whatnot in some key ways because of this issue of military discipline. So that's a key issue. We'll talk more about how this plays out later, but that is a very different goal. In other words, the civilian system at the end of the day isn't really concerned about whether we're making good employees out of people who get entangled in the system. They're not concerned with this broader mission that's related to the institution. It's much more general and vague in nature. In the military, it's very specifically focused on military efficiency and discipline. So, another key difference in the systems is the issue of who are the players, who are the participants in these systems. And so I want to talk about these a little bit. We'll begin, though, by comparing, and I'm going to focus today on the state criminal defense system, and for a couple of reasons. One is that more of you are familiar with that. Also, I am more familiar with that. I had not done federal criminal defense law. I've only done it on the state side, and of course military law, which is part of the federal system, but I haven't done federal civilian criminal defense law. So I'm not going to talk about something that I don't know a whole lot about other than just in my own study. So instead I will talk, though, I will compare the two systems from the standpoint of looking at how the state system compares with the military system. So in a state criminal proceeding, who are the players? Well, you begin with the parties in the case. State of Oklahoma or state of wherever versus John Doe, the defendant. So you have a plaintiff and you have a defendant. And in this case, the plaintiff represents society as a whole through the prosecutorial system. On the state side, they are represented in Oklahoma by a district attorney. And of course, on the federal level, be a U.S. attorney. In Oklahoma, though, very few of us ever deal directly on the defense side with the DA. We mostly deal with ADAs, assistant district attorneys. These are the people that day in and day out make many of the decisions. They are the ones we go to court with that are sitting at the other table. The DA, again, is giving that general, broader direction, guidance. And in a smaller county, maybe making many of the calls. In a larger county, the ADAs have a great deal more power. So our day-to-day interaction is with the ADA, but the final call of whether a case is brought to trial and whatnot, whether it's moved forward, is done through the DA. Now, for the defense side of things, in the civilian system, there are two options. A defendant is either defended by a private attorney of their choosing, who they hire, who they normally pay money to, or if they're lucky, they get someone to do the case pro bono. But again, almost always paying money. And then the other option is for indigent people who've been found to be indigent through the system. They may be represented by a public defender. So those are the parties. The state versus the defendant. Each is represented by, on this side, by the district attorney or ADAs. On the other side, by a private attorney or a public defender. Now we also have the judges. In Oklahoma, interestingly enough, like many states, the district judges are elected, but then the other judges may or may not be, depending on what level they're at. The jury is a key component of cases that go to trial. The jury is going to be randomly selected, and then through a vetting process for the voir dire process. And at least theoretically, the jury pool should look something like the community where the defendant is from. And then finally, other players in the system are going to include, after a trial, and assuming there is a conviction, you're dealing then with issues of clemency, parole, and there's all the players involved with that. So this is the personnel. These are the people that the system deals with. And I should add here, and this is an important one, is paralegals. Paralegals are a key role, particularly on the defense side, for many attorneys and for many public defenders. And for many clients, those paralegals are people they may deal with as much or more than the actual attorneys. And so they're an important part of the process. And we'll talk about them more on the military side as well, because I think that they are a huge part of the process, military side of things. So that's the civilian system. And again, I'm comparing it with state criminal defense in Oklahoma. Every state's a little different, but the general skeleton is the same. Now, let's consider the military system and look at it compared to the civilian system. In the military system, the list of players is similar, but with some notable additions, some pretty big additions. First and foremost, in the military system, we deal with the command. Now, the command is referring to normally what's also called the convening authority. Normally, it's going to be the post commander for a major installation. It may be a smaller level of command depending on the situation. But the command in a military case has a great deal of power, much more power than would normally be present in really any person in the civilian sector. Because the command in the military system has the power to make a decision whether or not a case is prosecuted or not. And if not, what alternative means may be used to achieve the military's goals. For instance, will a soldier be kicked out with a bad discharge, given administrative discharge? Will they be given a Chapter 10 discharge in lieu of court-martial? Will they be mercifully let out on some other grounds? Will they be allowed to continue their military career? Will they be given a lesser form of punishment called Article 15? Punishment. These are all decisions that are made by the command. In some ways, you could compare this to the role of a DA in state context, where the DA is the one who makes the final decision, but the ADA is the one you deal with on a day-to-day basis. But it's a little different in that are not only to decide whether to prosecute or not, whether to agree to an alternative situation, but also to make decisions about where this person is going to live of this trial, what's going to happen after this trial is done. Even though they're not guilty, even if there's not a conviction, the command can make decisions that can radically change someone's life for good or ill. And so the command has a great deal of power beyond just the case at hand. The command also actually convenes court-martials. Now, what this means is, in the civilian world, right now, I'm sitting here in downtown Oklahoma City. Graciously, my brother's office here, the Branum law firm, my brother John, has let me use his office as a nice place to do this recording. But a few blocks from here is the Oklahoma County Courthouse. Well, that courthouse was created, that court was created, I think at statehood probably, when the Oklahoma Constitution set up the district court system. And so that court is always in existence. It doesn't spring into existence and spring out of existence. It always exists. The military system is different. While there might be a physical courthouse in a particular military post, while there might be an assigned judge who's always available to take on cases, the court itself, in some theoretical sense, does not exist until it springs forth when it is convened into being. which is really weird when you think about it, but that's how it is. And so because of that, what that means in effective terms is that, again, a great deal of power rests with the command. Also, another power of the convening authority is to decide who's going to be on the jury, quite literally. Now, in the military context, we call this a court-martial panel, not a jury. But in any court-martial that moves forward and actually is going to be decided by a jury, and the defendant has the right to say yes or no on this, if the defendant says, I want a jury, or in this case, a panel, for an officer, it's going to be all officers on the panel. For an enlisted soldier, it will either be all officers or half officers and half enlisted. The problem is that sounds great that at least it's half enlisted, but here's the problem. Those enlisted are handpicked by the convening authority, and they will all be high-ranking enlisted personnel, NCOs, non-commissioned officers, sergeants and above. In other words, for the average defendant in the military justice system, there is no such thing as a jury of one's peers. There will be no one on the court-martial panel who is the same rank as the accused in most cases. And so there is a huge gulf, a huge gap in experience, and a huge gulf between the understandings and just life perspectives of these two groups. And so that's a real problem. But also what it means is, again, the command has tremendous power. If the command thinks that someone is going to be easy on someone, going to be lenient, well, that person will not be generally picked to be on a court-martial panel. That's a real problem. Also, in the context of plea negotiations, who makes the final call? What happens? What's accepted and what's not? Well, it's not the prosecutor. We'll talk about their role in a second. It's important, but they make recommendations, but the final decision is not made by the prosecutor. The final decision is made by, guess who? The command. This, in my opinion, is a real problem. Now, there are issues that in the military, there is the issue of what's called unlawful command influence, when a command tries to influence the system in inappropriate ways. But in most cases, the command never has to do this, and this motion never comes up because the system is already designed to give the command a great deal of influence on what happens. In other words, this is designed to elicit, when a command decides to prosecute, it's designed to get a conviction, in my opinion. So these are big negatives, the role of the command. You can't get away from this. Now, the justifications for this in the military context is that the military needs discipline, and military discipline hinges upon the system having this great deferential respect to the command. The command is focused on not the role of the individual, but the mission and the collective whole, and therefore a great deal of power is given to the command. Certainly from a military efficiency standpoint, that makes sense. From a justice and humanity perspective, not so much. Okay, we talked about the command, and we'll talk more about the command both in this presentation and the next second hour. But let's talk about some of the other players. The role of prosecutors we should talk about here. They're a little different, but there's also some similarities with the civilian system. First of all, though, is terminology is a little bit confusing. Depending on which branch of the military you're dealing with, we'll use different terms. For instance, most of my experience has been with the Army, and in the Army side of things, they call them normally trial counsel, or sometimes just SJA, staff judge advocate, but normally trial counsel is what you normally hear. You hear different terms in different branches for both the prosecutor and the defense side, but my experience is mostly Army, so that's what we'll talk about. Now, the trial counsel or the staff judge advocate, they wear several hats. One of the hats they wear is that of being the command's legal advisor. So the prosecutor is not only the prosecutor of criminal offenses, but also advises the command on every step of what they do. So if a command is thinking about doing X, Y, or Z, who do they talk to find out if it's legal or not? They talk to their JAG, they talk to their trial counsel. And so these people have an intimate connection with the command, and depending on what level of the command the JAG is dealing with, they may meet with them very often, they may meet with them just once a week or even once a month. It just depends on the individual post and caseload and everything else. But at the end of the day, these decisions are made by the command. The prosecution simply is there to advise and say this is legal, this isn't legal, but the actual decision of what happens in most cases still rests with the command. Now, that's not to say the prosecutors do not have power. The prosecutors are the ones who do the initial, once the command effectively has referred a case over, sent it to make a decision whether prosecution will happen, one of the steps will be the prosecutor looking at this and saying, yay, nay, this is a good idea or not. At that point, then, they are going to talk with the command. Decision is going to be made. And then once the ball is rolling, the initial charges have begun. In the military, there's a referral and referral system. It's a little bit muddy and complicated. We can talk about, that's really out of the scope of this presentation of how that exactly works. But generally, what I'll say is for the role of the prosecutor is that they are the ones dealing face-to-face with the defense counsel. At the same time, quite often the answer when discussing particular possibilities will be, I have to go back and talk to the command, or I think I can sell the command on this, or I don't think the command's going to go for this, but we can try. You hear that a lot. In other words, throughout this system, the prosecutor is more go-between than anything else. But at the same time, the prosecutor will also be the one that when this case goes to trial, who will be arguing it? It will be the prosecutor. It will be their tactical decisions that are at play. And so these folks are really important. Now, what can I say about these prosecutors? Well, first of all, I can say that they are very well trained. These are all law school graduates, of course. But then after that, they go to a special JAG school, and they do extensive continuing training throughout their military career. They also, after most trials, they have a session called the Bridging the Gap session. And during this, the military judge will sit down with the prosecutor and the defense counsel. And if you're lucky as a civilian practitioner, sometimes you'll get to sit on these too with the military defense counsel. You get to hear basically the judge critique the case after the fact. And the judge usually will not go into the deliberations of how he or she decided this or that, but will instead critique both sides on how they practiced, how that they explained things. And this is a very, very awesome tool to get to learn from. And so because of that, again, military attorneys, I think, are very well trained. And having this ongoing experiential training from the judges themselves is very useful. Okay, so we've talked about, so far, we've talked about the role of the command in the military context. We've talked about the role of the prosecution. Let's now talk about the defense side of things and compare that with the civilian system. Well, in the defense system, what is very unique and I think really cool is that the right to counsel, with one exception we'll talk about later, but one major exception is very, very awesome and very helpful to the defendant. The most notable being that unlike the civilian system, a defendant in the military system has the right to a government paid for attorney, whether they are indigent or not. They do not have to prove they're indigent. They get one. They can fire that person. They don't have to use military counsel, but they have someone paid for, and they don't have to prove they're indigent to get this. And so because of that, almost every defendant will be represented by counsel provided by the government. The Army, they are called TDS, Trial Defense Services. For the Air Force, they're called ADC, Area Defense Counsel. The other branches, I don't know because I haven't dealt with them in a trial in quite a while. But on the Army side, TDS is who I mostly deal with. These folks are very experienced. In fact, my understanding is that most TDS, maybe all TDS attorneys, begin on the prosecution side, and later, if they work out well, they get moved over to the defense side. They are also under a different chain of command than the prosecution JAG. So when you become a defense attorney, you switch chains of command, which helps to avoid some of the legal ethics issues. They also, from what I can tell, is scrupulously, both sides, careful to follow the rules and to keep their client's interest at stake, meaning that they will be friendly and civil with each other, but you're not going to see any inappropriate sharing, anything like that. And it's just like in the civilian world that people may be civil, they may be nice, but there's a limit to how friendly you can be, given the confidences each side has. And in the military system, what I've seen is they are very scrupulously rule followers when it comes to that. So the positives of the TDS attorneys is they're very experienced, they know their stuff, and they know military culture. They are part of the military, just like the prosecution side are. Now, some defense and prosecution attorneys in the military were prior enlisted. Maybe they served before law school, maybe they were in the reserves during law school, and later became officers and became attorneys. Others went straight from law school to officer training and then their final JAG training and then become lawyers. My experience has been that those attorneys who were prior enlisted first have a lot more experience. Sometimes those who have been officers the whole time, they may not relate as well to the experiences of enlisted personnel. So that's a bit of a negative. Also, I'll say that my experience has been that the trial defense services, the government provided legal attorneys, legal side of things, they can be overly cautious, in my opinion. For instance, they are not ever going to use press outreach in any way, which in the civilian cases sometimes is a useful tool in various ways, particularly though in the military context, I think it's essential at times because the military, despite its protestations not to be, is a fundamentally political institution, which is ran at the top level by a commander-in-chief who is elected through a political process. Hence, public pressure can sometimes change the outcome in a case, particularly in the military world. Unfortunately, TDS attorneys, with very few rare exceptions, will not talk to the press, even if it, in my opinion, will be helpful to their clients. And so that's why often it is helpful for there to be an outside attorney, and that's where civilian defense counsel, CDCs, come into play. And I'm one of those people. And other civilian attorneys who step into the system, when they do that, they become CDCs. Now, the role, and what's nice, I love in the military system, is that the client doesn't have to pick which either or. They can go with both, meaning they can have retained, they have their own private attorneys retained, but they also get to keep their TDS or ADC or whatever, which branch of the military they're in, their defense counsel through the government. And so what normally happens in practical terms is the civilian attorney sits first chair, the military defense attorney sits second chair. In different cases, there's been different working arrangements and how that all works. But my experience has been a very, very good relationship getting to do that. As a civilian attorney, what I really appreciate about working with these military defense attorneys is they know military culture in and out. While I worked as an attorney with military cases for 11 years, I haven't lived a military life ever. I'm not a veteran. I haven't served in that kind of way. So I don't catch a lot of the nuances in military culture that people in the military will. And so I find that to be very useful. Also, it's just nice having another attorney, particularly a solo practitioner, to have another attorney to bounce ideas off of, to really engage with. So I find it to be a really useful situation. Also, it's extremely useful when you're dealing with issues of distance. Military posts are scattered all across the country and all across the world. And so many people civilians who practice military law, end up having to travel a lot. And so it's very helpful to be able to have someone local often to do some of the legwork and to meet with clients and to have them come to the office as a TDS office and meet with them. And often for me, just a civilian lawyer, to be on conference call with them and the client. So I find it to be a really neat system. And so there's a lot of gripes at the military system. This isn't one of them. I think right to counsel generally is very, very good. With, again, one exception, the good old summary court martials we'll talk about later on. But generally, very, very good. Also, while I'm talking about the prosecution and defense attorneys, I shouldn't mention the role of military paralegals. Military paralegals are trained, these are usually enlisted personnel who have gone through the MOS, military occupational specialty, which you call your job with the military. Whatever your job is, they've gone to MOS school for paralegal school. And so these are folks who know how to get things done. And so oftentimes I end up working a fair bit with these folks on cases. And while I may have, the TDS lawyer, particularly some of the branches of the Air Force, those poor folks, they get to cover off in multiple military bases. There's not near as many as cases pending. So you may have someone who's traveling between, say, 4 or 5 different states. So who runs the place in the interim? It's those paralegals. They're the ones who are available day in and day out. And so those are really good folks. The one that practice tip I give for anyone watching this is be nice to the paralegals. These are folks who can help you. These are folks who, if you don't treat them well, they may not have the motivation they need to do. Basically, treat them well. Be nice to them because they have a hard job, and it will yield good results. But it's also just a nice thing to do. Okay, so now dealing with more of the players in the military system, let's talk about the military judges. Now, unlike the convening of the court in this general sense, we talked about earlier, the command convenes it into existence. The judges themselves are part of their own chain of command. They're called MJs, military judges. These folks are very experienced, in my opinion, usually fair. They would normally be fairly high-ranking, normally at least lieutenant colonel or higher, and they will have most likely been previously a JAG attorney of some kind. So they've been on the practice side as well. I don't always like how they rule, like all of us do when it comes to judges, but as far as fairness, as far as knowledge of the law, these folks are really on top of it. They are usually older. And so, particularly in dealing with a judge-alone trial, I do try to bear in mind the generational gulf sometimes between service members themselves and the judges they're dealing with, because that gulf can be a big factor. So, by the way, this is a good time to do the first of our codes. Remember, we talked about at the beginning, if you want CLE credit, you need to write down these codes. It'll be 2 per hour. So the first code is B as in Bravo, 5, V as in Victor, L as in Lima. Okay, let me repeat that. Again, I'll give you a minute here to get a pen or pencil if you don't have one already. The code for this first code is B as in Bravo, 5, V as in Victor, L as in Lima. So when at the end of this program, as we talked about earlier, you'll need to send us an email to girightslawyer@gmail.com. That'll be on, by the way, the CLE page if you're on the website, or if you're looking at the chat thing on the Google Hangouts we're using for this video stream, you'll find the email address as well. But email me with your name, your state, your bar number, and these codes. And basically send me the codes for the parts you listened to. If you didn't watch the whole thing, you'll get credit for what you did watch. But there'll be 2 per hour. So the first code is B as in Bravo, 5, V as in Victor, L as in Lima. Okay, so that was code number 1, B5VL. Okay, so let's continue onward. So far, we've talked about in comparing the players of these 2 systems. We've talked about the parties. We've talked about the attorneys. We talked about the judge. Let's finally talk about 2 other levels of this. First of all, the court-martial panels themselves. Now, the military context, this is what we call another word for a jury. And as we talked about earlier, this is picked from a list that's provided by the command, a list of people. It'll be a list of officers and a list of enlisted personnel. If the defendant is officers, the whole pool will be picked from the officers. If it's enlisted, they have the option of saying all officers or half officers, half enlisted. By the way, I should tell you, conventional wisdom for enlisted personnel is that it's usually better to ask for all officers, because those high-ranking enlisted, because again, you're not getting juries of your peers. If you're low-ranking, you're getting high. If you do ask for half enlisted, they will be high-ranking enlisted. And I need to turn that off. Okay, sorry about that, folks. Normally, if an in-person presentation, I would say something about turning off your cell phones, but I forgot to do that myself. So it's turned off now. Okay, so continuing onward. Anyway, the conventional wisdom is it's usually best to ask for all officers, but whether that's true or not, I don't know. I've had one go to a panel. In that case, the defendant decided to go with all officers. But generally, I will say cases that go to a jury trial in the military are fairly rare for some reasons we'll talk about later on. But for those that do, the problem is it is not a jury of one's peers. It's going to be all high-ranking people handpicked by the command who made the decision to prosecute the defendant in the first place. So not a good situation at all. Finally, after a trial has happened, and after, presumably, in this case, a conviction has happened, now the defendant has a chance to ask for clemency and to go through the parole process. On the clemency side of things, what happens is post-trial, the defendant has the right to present other matters in writing or in other forms that they want, but writing is what they're guaranteed to be heard on, to the convening authority. And the convening authority then, after the decision of the judge is made, It gets sent up to the convening authority, usually be several months down the road. At that point, the defendant then makes their request for clemency to the convening authority. The convening authority then looks over, at least is supposed to look over the record of trial and look at that request for clemency, and then we'll make a decision whether the original sentence will be continued or whether clemency in some way will be granted. So positive is, in some extraordinary cases, things can change. An injustice that happens at trial can be fixed. Bad news is, it's the same person making the decision throughout the way. The command, the decision of who to prosecute is made by the command. The decision of whether trial moves forward belongs to the command. What kind of plea negotiations, if any, are accepted, decided by the command. And finally, whether clemency will be granted and how, made by the command. The only intervention in this really is the prosecution's ability to, as the prosecution and the defense, their arguments back and forth as persuasion pre-trial to stop a trial going forward. And then, of course, there's the role of the judge. You can't have and or the jury pool, in this case, the court-martial panel. Those are checks as well. In other words, the command can't give someone a conviction and a dishonorable discharge if they haven't gone through this process of being convicted by a military judge and or the court-martial panel. But other than that, every other step of the way, who has control of it? It is the command. And that's a really important point. And I think it's something we can't underestimate. The command has power through this whole process. So anyway, so for just a moment, let's give it a little critical look at. We've talked looking at the players in these two systems. What would we say positively and negative about each? Well, the big positive in the civilian system is that the various players have much more independent power, which means the prosecutor has the ability to make decisions without necessarily going all the way up to someone like a command in the civilian context. There's a lot more independence by the person who actually is trying the case to make a decision. While in the military context, the command makes a decision. And at the end of the day, what the prosecutor thinks is simply a recommendation to the command. It's not the actual. And so I think that's a shortfall of the military system is that so much power, and that power could be wielded unfairly. I also think that the role of the jury is far superior in the civilian system, where you have the jury panel is truly picked randomly through, and then a vetting process through voir dire. In the military system, I forgot to mention too, voir dire is much more locked down in the military system than it is in the civilian system. All of the judges, when asked of a potential jury panel, have to be approved by the judge in advance. This does not allow the kind of open-ended questioning that you're allowed in the civilian context. You're much more strict on what you can ask for. And even if you got a particular court-martial panel member knocked off, it may not be that helpful to you because, again, every member of the jury panel has been handpicked by the convening authority. That's a shortfall of the system. Now, positives in the military system is the defense right to counsel, the fact that everybody gets a good attorney. And I should also add, let's say that you can't afford a private attorney. You get assigned a military-appointed attorney that you don't like, doesn't click, you just don't think is doing good for you. You have the right to fire that person and ask for another attorney if they're reasonably available in the military system that the government will pay for. That's extraordinary. I can't imagine the civilian system if someone had a bad relationship with a particular public defender that they could ask for a different public defender and actually have that request to be honored. It's very unlikely. In the military system, that's embedded in rules. And of course, then you also have the right to hire a civilian attorney as well at your own expense, and to have that attorney sit with and work alongside the military provided attorney. It's such an awesome, awesome benefit, in my opinion. And finally, the fact that in the military context, defendants get their attorneys, get their government provided attorneys paid for whether they are indigent or not, or whether they can prove they're indigent. You know, anyone who's dealt with the system knows there's a lot of poor people in the system who may not be able to fit under the bar for the government would deem to be indigent, but maybe desperately poor. And their family goes through tremendous financial, in fact, you know, the normal scenario is the family goes through tremendous financial hardship, just gets someone bailed out in jail. They've blown through all the money for that, and now they're expected to get an attorney. And what do? They have a very limited choice of who they can pick because of finances. In the military, that's not the situation. Everybody at least gets their government-appointed attorney that's paid for by the government. It's a real positive benefit. By the way, we're getting a few more viewers on here. Excited to have everyone on here. If you have any questions along the way, I don't have it set up with the video and audio where we can talk. It gets a little bit muddy when I've done that before. But we do have a chat thing on the side of the page. And so if you want to have any questions for me along the way, I'll do my best to look at that occasionally and answer any questions you might have. So I do want this to be a two-way conversation to the best extent possible. So thus far, and kind of covering a little bit for those of you who are coming in later, thus far in this presentation, we've talked about the different goals of the military versus civilian systems. We've also talked about the various players in the military versus civilian systems, comparing and contrasting these two systems. So now I want to spend some time talking about the differences in procedural rules in practice. In other words, the nuts and bolts of how you do things in each system. How do you figure that out? How do you learn how to do those two things? In the civilian world, and again, we've been talking throughout this, comparing the Oklahoma criminal justice system. Other states will be similar in various ways. But in Oklahoma, what do we look at? We're looking at the rules of criminal procedure. We're going to be looking at local rules. And of course, we're going to be looking at, along the way, sometimes case law, constitutional issues, and whatnot will also bear on procedural issues. But generally, we're looking at rules of criminal procedure, we're looking at the local rules, and then also lots of unspoken details that vary from location to location of which form you use for what, who do you talk to when it comes to docketing and all that. Those all vary greatly from county to county. Also, in Oklahoma courts right now, and it's moving more in an electronic direction over time, but right now you still often have to meet in person for all kinds of things. Often something just as simple as a quick schedule change requires a meeting with both parties in person in a courtroom. The military system, thankfully, has made things much more efficient and much easier on that front. We'll talk about that more in a second. In the military system, procedurally, we're looking at two primary documents. We're looking at the UCMJ, the Uniform Code of Military Justice, and we're looking at the MCM, the Manual for Courts Martial. By the way, that was the 900+ page document I mentioned you need to download if possible. And we'll be looking at that some throughout today's presentation, both the first and second hours. But the UCMJ primarily gives basically the laws of military, the criminal statutes, basically saying what the penalties are very, well, actually not giving the penalties. Also, that's actually in the MCM. That's kind of an interesting thing. But the actual definitions of crimes is found in the UCMJ, which has the status of federal statute because it has been enacted by Congress, signed by the president, yada, yada. So the UCMJ provides the criminal statutes, but it also provides some, but very vague and not all of the procedural details of the criminal justice system. Much of the details are spelled out in the MCM, the Manual for Court Martial. The Manual for Court Martial has the status of federal regulations because they are enacted by the president through the president's power as commander-in-chief. That's the constitutional justification for it. What to me is interesting and kind of troubling, though, is that the MCM functions in many ways more like a federal statute. For instance, the penalties for various crimes, how much time a person does if they're convicted of X offense or Y offense, that's not defined by federal statute, the UCMJ. It's defined by the MCM, the Manual for Court Martial. Now, that to me seems just weird. The president gets to decide what the maximum lengths of sentences should be. To me, that seems very inappropriate. It's one of my critiques of the military system. But nonetheless, that's how it's structured. And up to this point, at least, the courts have allowed that to be. But the MCM also, besides giving the penalties for crimes, gives a lot of commentary on the UCMJ, explaining in more detail issues related to each of the offenses, and then also gives much more of the procedural details of what happens in a court-martial and what happens in various other contexts. There are also usually branch-specific regulations, or DOD regulations and branch-specific regulations on military justice that also fill in more of the details. Now, that's what the rules on paper. As far as how you actually get things done, what I like with the military system is these days, almost everything is done through email. which means many of the issues that you would have to go and travel to a county courthouse in the civilian system, if you're lucky, maybe get it hashed out on the phone with the prosecutor. It most often requires a in-person visit, possibly in front of a judge and all of that. In the military, often these issues are dealt with in email, and either conversations directly between prosecution and defense with various things, but also sometimes when it comes to docketing and whatnot, it's going to be a conversation between those parties and the judge. They're all on the CC together, so we're not having ex parte communication issues. This, to me, makes things so much simpler, particularly when it comes to plea negotiations, when you're trying to hammer out the exact details of what someone's pleading to. Military pleas are quite a bit more complicated in some ways than the civilian world. Usually there'll be a very, very detailed stipulation of facts. Well, the details of how that gets hashed out is not having to be done in person. It's done through email. And for me, I like that for many reasons. One, of course, is it eases the gap of distance between the practitioners that need to talk about these things. But secondly, and I think more significantly, is that it provides a paper trail. And I think for me as an attorney, it helps me to remember what is said. It's not just my own recollection or my own written notes, but I can actually look at the emails and say, oh yeah, the prosecutor said X, Y, and Z. It really is so useful. And I just like the efficiency of the system. It makes things go so much easier. And it's remarkable, really, how well this system works. And you have attorneys, one case I had that was at Fort Carson, Colorado. The judge was flying in from Alaska because she was previously sitting on trials up there. And she was on a circuit working all the way from Alaska. And the week before, all the parties and the judge are dealing with things by email. She's in Alaska. The prosecutor, I can't remember if he was in California at that point or if he was at still Fort Carson, and I was in Oklahoma. We could hash out many of these details that needed to be dealt with, provide the appropriate notices and whatnot. It'd all be done by email, and it just goes so smooth, super smooth. So to me, that is one huge benefit of the military system, is a great deal more efficiency. Okay, lastly, I want to talk about, we don't have a whole lot of time left. I want to talk a little bit about how the laws of these two systems compare and contrast. What can we say about them? And again, I'm today mostly focusing on state criminal law. Federal is a little bit different, but on the state side of things, we think about what are the statutes, what are the basis of law we're dealing with. Of course, it's things written down and things in case law. Well, I guess case law is written down too, but you know what I mean. On the first side, of course, is you're going to have at the very top of the food chain on this side is the Constitution of the United States at that federal level. And of course, certain provisions, those provisions that do apply to the states, then that affects the state criminal system. Then next we have the state constitutions. And many states, including Oklahoma, have Bill of Rights, have other things like that in them, some basic protections given in the state constitutions. That will trump what's below that, which are the state statutes. And then sometimes there's also issues with state regulations. And then, of course, there are the rules of the various courts and whatnot. So it's you have a pecking order here. Those at the highest level will trump those below that, and so on. That is on the state side of things, and the civilian side of things. So we compare that now to the military system. It gets a little more complicated, but it's a very similar kind of concept. And to me, understanding this hierarchy is super critical. And without this, it's easy to get things really muddied. So at the top of the list for those in dealing with the military system, you have the U.S. Constitution, just like on the state side. Also, just like on the state side, there are certain provisions of the U.S. Constitution that do not apply to states. There's some of that only most things do, but not everything. And the same thing in the military side of things, there are some provisions, procedural protections in the military that do not apply to the military. I disagree with this decision, but it's in case law. The rationale is, as we talked about earlier, the issue of military discipline. Since the U.S. Constitution gives the president the power to be commander-in-chief for the military, the idea is that there is inherent in that an implied powers to maintain military discipline, which means that some of the constitutional provisions don't apply in military context, such as free speech. Free speech rights are dramatically limited for members of the military, not extinct, but in a way somewhat similar to federal civilian employees. For instance, they can't run for public office in most contexts as an active duty member of the military. They are limited if you're wanting to engage in a protest or demonstration as a member of the military. You can't do it while wearing a uniform, on a military post, in a foreign country, or in any way that there might be a chance it could result in violence. Great limitations on one's abilities of free speech. A whole lot of other things. But also we think about those procedural protections when it comes to a court-martial. What doesn't really apply to the military? Well, first of all, the right to a jury trial. As we discussed earlier, there is no jury of your peers in the military. It's a jury of people who are way up above you in rank, not really a jury of one's peers. Right to counsel in some ways is better than the civilian world, unless you're in a summary court-martial. We'll talk about that in a second. There's an exception there as well. So there are some differences in these two systems. And at this point, it comes to the very highest level. There's provisions of the U.S. Constitution don't apply. Also, I should mention right to bail. There is no right to bail in the military. Instead of bail, there's the issue of whether you're put in pretrial confinement or not. But that's all there is. There is no bail as we know it here. Part of the argument, though, here is that a person in the military is always still in custody in some way. Even if you're living off post, you're still subject to the UCMJ if you're active duty. So bail, that's the argument made. But nonetheless, if the command decides they want to hold you before trial, they usually get away with it. There's a process you can contest if they basically most defendants are not put in jail, but those who are, it's called pretrial confinement. You can contest pretrial confinement, but very few people are successful in doing so. And again, the decision to grant pretrial confinement, it's a much lower bar than it is whether someone could be denied bail or not. But anyway, the top of the list, as we mentioned earlier, U.S. Constitution as defined by the courts through those military-specific exceptions. Below that are federal statutes. Now, the biggest federal statute we deal with in the military context is the UCMJ, Uniform Code of Military Justice. But there are other federal statutes as well, such as some of the equal employment statutes, such as conscientious objector statutes, some of the whistleblower protections. There are things that are written in other federal laws that are also at this level. But anything that is a federal statute, in other words, that has been enacted by Congress, signed by the president, that is higher than everything else except the Constitution in this pecking order. Now, below federal statutes, and I should also add, it is a very small number of federal statutes. We're not talking about a huge number here. It's fairly small compared to in the civilian context. Most of what we think of in the law of the military is at the next level, and that is federal regulations, except in this case, it is a multi-tiered system of regulations. All of these are federal regulations, but some of these are higher than others. And I would put these in three categories. At the top are DoD regulations, Department of Defense regulations that apply for the whole Department of Defense. I should add, one other complication is you have DOT, Department of Transportation, you deal with the Coast Guard. That's kind of a whole other category, so I'm not going to deal with it right now. But for the most part, we're dealing at this level at DoD regulations, which apply to the entire Defense Department, all branches. Now, DoD regs tend to be more vague, the idea being that the branch-specific regulations give more detail and allow some flexibility from branch to branch to do things a little differently. But the DoD regs do prevail over branch-specific reg, meaning that if a branch-specific reg contradicts the DoD reg should be followed. So that brings us next to branch-specific regs. And 90% or so of what you deal with in military law context has to do with branch-specific regulations. Those are the regulations that apply at the branch level. So, for instance, ARs is what we call them for the Army. Army regulations, such and such. Air Force has their regulations. Marines, the Navy, each branch has their own sets of regulations. I should add one positive is that most of these regulations are online. The negative is not all of them are. And it's often a big pain to track down the regulations that are not online, but most of them are. And usually, you just need to do a Google search for the regulation you're looking for. This type hierarchy of regulations is DoD regs, then branch-specific regs. Third level are post or command level regulations, instructions, etc. That's going to include one of the most common ones is most military posts will have an off-limits list. For instance, in most cities, there'll be a post for an army town. There'll be a list of places that soldiers are forbidden from entering. It's usually places where there's been prostitution, drug use, other things like that. And so so that you're forbidden from going to those places. And if you go in those places anyway, then you're guilty of an offense under the UCMJ. There's other things like that. There may be regulations. Some posts have detailed regulations on motorcycles, saying if you drive a motorcycle on post, you're required to wear a special orange vest while on post, and you're required to go through a special motorcycle training. That's all at the post level. And so again, in this hierarchy, DoD regs, then branch regs, then post regs. So each of these levels is a hierarchical system. So again, comparing to the civilian context, you have a lot more layers and levels of complexity. So anyway, so that's as far as what's written on paper. We now deal with case law. And case law in the civilian side is much more extensive. We have a whole wealth of appellate court decisions, recorded decisions at the state level and also the federal level, interpreting various levels of constitutional issues. We have, of course, persuasive authority and binding authority. In other words, binding authority is those decisions made by a court, either the court that we're dealing with or a court that's over that court. Persuasive authority is being a decision from another court that's not in the pecking order over here, but could be persuasive to this court over here. So we have tons of case law in the civilian context. Military context, not so much. Not near as many cases go up on appeal where there's actually a recorded decision. And so a lot more issues are unsettled, a whole lot more issues, which I think is exciting as a possibility as a defense attorney, but also frustrating. You don't always know how it's going to play out, which is very frustrating. To the extent that there are recorded decisions, you're not normally going to have much at the trial level, which would be the equivalent in the civilian world of, say, a district court on the state or federal level. What you will instead have are the Court of Appeals for the Court of Criminal Appeals. Each branch has their own appellate court, and then below that is the Court of Appeals for the Armed Forces. And I'm going to real quick pull up one thing. I did some notes here that's important. I don't have those handy. Anyway, that Court of Appeals for the Armed Forces as a whole, and then finally above that, you're going to have any time that you have either be kicked up to the U.S. Supreme Court or at any level, you also could have collateral attacks, habeas review in a civilian court. The challenge is that most civilian courts do not want to interfere in a military proceeding, hence they are very unlikely to accept these kind of cases. So there's much less case law out there, which can be challenging. Okay, we've covered a lot around here. I do want to open this up to questions. If anyone has questions, go ahead and type them on the chat screen that's on the page we're looking at here. But while I'm waiting for any questions, I just want to mention, to me, what I want to say as far as what we can learn from these two systems, what each system could learn from the other. I think the civilian system could learn a lot from the military system of saying that no one is served by having defendants without good counsel. I know a lot of people think, that feel like that we need to, in our desire to punish defendants, we need to not give anyone a free attorney for a defense case unless they really prove that they're desperately poor. But the military has decided that no, you really can't have a fair trial without an attorney. If someone can't afford an attorney or can't afford one that they feel comfortable with or that's good for them, they're not going to get a fair trial. And so they've said that everyone gets one, no matter what your indigency situation. And really the only choice is, do you want to accept that person or not? And I think there's a lot to be merited by that in the civilian system. And I realize it would make the system more costly in some ways, but in some ways, I think it might also make it more efficient. Imagine if the public defender offices in this state or other states were not just funded in the low way they are, but funded quite well, so that every person in the system who wanted to be represented by a public defender could get a public defender and have someone who did not have a ridiculously high caseload, but had a more reasonable caseload, probably something equivalent to what the number of cases, say, the ADA, each individual ADA is dealing with. No more than that. What would that look like? Well, my theory is that it would mean a more efficient system. Continuances while someone is waiting to come up with the money to hire an outside lawyer. It would probably mean that more cases move forward in an expeditious way. And I think also by having people have good attorneys, no matter what it would mean is less wrongful convictions, which would mean for society as a whole bunch of benefits, to say nothing of just having a more fair, more just system. I think that's a huge benefit the civilian system could have by adopting something the military is doing. Now, on the military side of things, what could they adopt from the civilian system to be better? Well, the biggie would be to eliminate or greatly reduce the role of the command. The command has too much power in the system, in my opinion. The command should not be picking, for instance, the court-martial panels. That should be done through some kind of random process. The list of names of who's eligible to serve on these panels should be done through a random computerized process. They can do it. They have all kinds of computers. No reason they can't. Also, the jury panel should actually be a jury of one's peers, meaning that the jury panel, I think, ideally should represent the demographics of the military, but also should represent demographically the ranks of the military. I don't think officers should get to have should have the privilege of being elected judged by their peers, but privates don't. That's not fair. I would also say that I'd say that's the biggie. I mean, I think also, I would also add for the civilian system, they could learn from the military in that, boy, email sure makes things go smoother. And if more things could be done through electronic means, it would help a lot. So, okay. Real quick, we're about to end our first hour presentation. I need to give the second code. This is code number 2. So please write this down if you're wanting credit for this. The code is D as in Delta, 9, Z as in Zeta, and A is in Alpha. So code number 2 is D as in Delta, 9, Z as in Zulu, A as in Alpha. Just a reminder, these two code we gave earlier on this one, you need to email those to me at the end of the presentation if you want credit to girightslawyer@gmail.com. Send me your name, state, and bar number, and these codes. And again, if you want there'll be 2 codes for the first hour, 2 for the second hour. Send the codes for the time blocks you want credit for. So we'll read it one more time. The second code, that is D as in Delta, 9, Z as in Zulu, A as in Alpha. Well, that finishes the first hour of the presentation. So we're going to take about a 10-minute break. When we come back, we'll get started with the second hour. So also, in the meantime, if you have any questions from the first hour you have, feel free to put them on the chat box, and then we'll add a message for those who are coming during the break, and we'll be back momentarily.